everyone, you're watching LiveLaw and this is Ostika Das. Welcome to another episode of Courts This Week, where we bring to you the most pertinent legal developments that took place last week across the country. The biggest development this week is the legal controversy over Sudipto Sen's The Kerala Story, which hit the theatres yesterday. The movie has made a claim that nearly 32,000 women from the southern state of Kerala were converted to Islam through deceit and sent on missions to Syria, Iraq and Afghanistan on behalf of the Islamic State, a terrorist organization operating in these areas. Initially, a plea for banning the release of the movie was raised as an interlocutory application in the hate speech case pending before a bench of Justices K.M. Joseph and B.V. Nagaratna. However, the bench refused to entertain the application, saying that it could not interfere unless a substantive petition was filed challenging the certification granted by the Central Board of Film Certification. On the same day, a batch of petitions were heard by the Kerala High Court, which sought the response of the centre and the producers of the film. However, the High Court declined to grant interim stay of the movie in view of its CBFC certification. The next day, two petitions, one filed by an Islamic clerics organization called Jamiat Ulama-e-Hind and another by Qurban Ali, were mentioned before Chief Justice D.Y. Chandrachud. Noting that the Kerala High Court was already seized of a similar matter, the Chief Justice refused to entertain the petition. On the very next day, the petitioners were back at the Supreme Court, saying that the Kerala High Court had refused to constitute a bench for early hearing before the movie was released. The top court, however, was unwilling to grant any relief. Chief Justice Chandrachud said, and I quote, "The Central Board of Film Certification has approved the movie. The Kerala High Court has refused to stay the movie. Yesterday, we declined to entertain the Article 32 petition. Now at this stage, we can't entertain this matter again." On the same day, the Madras High Court also dismissed a PIL seeking a ban on the release of the Kerala Story, which was set to release in multiple languages. On the day of the release, the Kerala High Court heard the petitions again. Refusing a stay, the bench noted, among other things, that the producers had added a disclaimer that the film was a fictionalized version of events and that the trailer was not offensive to any particular community. The producer, however, said that he would withdraw the teaser of the movie, which claimed that over 32,000 women from Kerala were recruited to Islamic State from all social media accounts, and this submission was recorded by the bench of Justices N. Nagaresh and Sophie Thomas. The Patna High Court has stayed the caste-based survey being conducted in Bihar in an interim order. The bench revealed that it prima facie found that the state government has no power to conduct a caste-based survey because it essentially amounts to a census which only the union government is empowered to carry out. While issuing the stay, the bench observed, and I quote, "We also see from the notification issued that the government intends to share data with the leaders of different parties of the state assembly, the ruling party and the opposition party, which is also a matter of great concern. There definitely arises the larger question of the right to privacy, which the Honorable Supreme Court has held to be a facet of the right to life." The decision came less than a week after the top court urged the Patna High Court to consider, decide and dispose of this interim application of an organization called Youth for Equality at the earliest. In a latest development in the defamation case against Congress leader Rahul Gandhi, the Gujarat High Court has refused to grant any interim relief to Gandhi with respect to his conviction under charges of criminal defamation for his "Why all thieves share the Modi surname" remark. Gandhi was convicted in March by a magistrate court in Surat and sentenced to 2 years simple imprisonment. Subsequently, he was granted bail by a sessions court, but his conviction in this case led to Gandhi's disqualification from the Lok Sabha. The decision on whether a stay would be granted on his conviction is going to be delivered by the High Court once it reopens after its annual summer break. In a significant verdict, a constitution bench of the Supreme Court has held that it can invoke its special powers under Article 142 of the Constitution to grant divorce on the ground of an irretrievable breakdown of marriage. While refusing to lay down concrete grounds, the top court has provided some broad and illustrative factors. We have discussed those in another video, the link to which is provided above. Importantly, the top court has held that the cooling off period prescribed under Section 13B of the Hindu Marriage Act may be waived off by it. However, the bench has said that this power is discretionary and is to be exercised with care and caution. Finally, the top court has held that this power under Article 142 may be exercised even when both parties are not consenting in order to do complete justice. The court should be satisfied on the basis of the facts that the marriage has completely failed and there is no possibility that the parties will cohabit together, and the continuation of their formal legal relationship is unjustified. However, no such order can be passed without balancing the circumstances and the background in which the party opposing the dissolution of marriage is placed. Notably, the top court has also issued a very important clarification saying that a party cannot file a writ petition under Article 32 of the Constitution of India and seek relief of dissolution of marriage on the ground of an irretrievable breakdown of marriage directly from it. Tempers were running high in the courtroom when a bench of Justices K.M. Joseph and B.V. Nagaratna was hearing the Bilkis Banu case. The petitions in this case are against the premature release of the 11 convicts who were handed life sentences for the horrific gang rape of Bilkis Banu during the 2002 Godhra riots. The hearing could not take place as scheduled since two of the counsel pointed out alleged discrepancies in Banu's affidavit on service of notice. It was submitted that even though two of the respondents were out of town, an affidavit had allegedly been filed by the gang rape survivor indicating that they had refused to accept the notice. The counsel furiously accused Banu of playing fraud with the court. However, the petitioners objected to this, saying that these were nothing but delay tactics employed by the other side to interrupt justice on flimsy procedural grounds. Justice Joseph also concurred with the petitioners. He said it was clear that the counsel for the convicts did not want that particular bench to hear the matter and were trying to wait out the rest of the judge's tenure. Justice Joseph is set to retire on June 16th, but since that is during the annual summer vacation, his last working day will be on May 19th. In another important development, after initially expressing their reluctance to share information pertaining to the remission of the 11 live convicts, the centre and the Gujarat government have both agreed to place the original records before the Supreme Court of India. The top court was informed that neither government would be claiming privilege over the information. In 1994, a young Dalit IAS officer was killed by a mob led by a few politicians, including former parliamentarian from Bihar, Anand Mohan. G. Krishnaiah, who was the district magistrate of Gopalganj then, was reportedly dragged out of his car and murdered in cold blood by a mob led by Mohan. So almost 3 decades later, why are we hearing about this again? That is because last month, the Bihar government removed a clause from its remission rules which forbade the premature release of those convicted of murdering a public servant on duty. Former MP Anand Mohan was handed out a death sentence by a lower court in 2007 for the murder of the IAS officer, but that was later commuted to life imprisonment by the Patna High Court. His conviction and sentence was also confirmed by the Supreme Court. But pursuant to the amendment in the Bihar Prison Manual, the state government has decided to release Mohan and 26 other prisoners. Not only has this move been met with significant backlash from political parties and the civil society, but has also led to the filing of a petition before the Supreme Court challenging this decision. The petition was filed by Uma Krishnaiah, the widow of the murdered IAS officer. When this case was mentioned before Chief Justice D.Y. Chandrachud, he agreed to list it on May 8 to be heard for admission. The Supreme Court has refused to stay a demolition drive to remove encroachment from South Delhi's Tughlakabad area. This area around the Tughlakabad fort was under the protection and maintenance of the Archaeological Survey of India, which was directed to halt land grabbing and encroachment by the top court back in 2016. Last month, the Archaeological Survey of India launched a massive demolition drive, tearing down nearly 1,000 homes and rendering an estimated 2.5 lakh residents homeless. Most of these people were domestic workers working in affluent houses in the city. daily wage laborers, and other people from underprivileged communities. This development followed closely on the heels of the Delhi High Court directing the agency to remove encroachments in and around the fort within 2 weeks. It has been alleged by the protesting residents that they were served evacuation notices only in January and that many of them have not been provided any alternative living arrangement. A bench headed by Justice Khanna refused to stay the demolition drive to remove encroachment but has agreed to hear the petitioners on the question of rehabilitation. In a major relief to the Chhattisgarh government, the Supreme Court has stayed an order passed by the Chhattisgarh High Court striking down the state government's move of giving 58% reservation. By a 2011 amending act, the government had provided 58% reservation to scheduled castes, scheduled tribes and other backward classes in public services and posts and to certain educational institutions established, maintained or aided by the state government. Last year, this scheme was quashed by the High Court as unconstitutional. It held that no exceptional circumstance had been made out for breaching the Indra Sohani rule, which lays down a reservation ceiling limit of 50%. Now, a bench headed by Justice B.R. Gawai has suspended this order. As an interim measure, the court has allowed the state government to go ahead with the recruitments on the basis of this policy under question. However, it has clarified that any appointment or promotion made would be subject to the final outcome of the proceedings. The Supreme Court has upheld the election of DMK leader Kannimozhi Karunanidhi as an MP from Thoothukudi by dismissing a petition filed in the Madras High Court challenging her election in the 2019 Lok Sabha polls. The parliamentarian had filed a plea against the High Court refusing to dismiss the election petition and proceeding on the ground that she had not disclosed her husband's permanent account number. The top court had stayed the proceedings before the Madras High Court in 2020. Before the apex court, Kannimozhi argued that her nomination records clearly stated that her husband did not have a PAN card, being a citizen of Singapore. The petitioner's claim that the nomination was improper was vehemently challenged by her on the ground that he had not brought a single material fact to substantiate his case. This argument found favour with the bench. While allowing her appeal, a bench headed by Justice Ajay Rastogi held that the election petitioner had made very bold and vague allegations without stating the material facts as to how there was non-compliance of any of the provisions of the Constitution of India or the Representation of the People Act. BJP leader Kailash Vijaywargiya has hit the headlines because of a recent Supreme Court judgment. So what is this judgment about? Vijaywargiya and two others have been accused of raping a woman and threatening to kill her and her son. The first complaints were lodged in December 2019. When the police reportedly refused to lodge an FIR against Vijaywargiya and the others, the complainant sought the intervention of a city magistrate. However, on the magistrate declining to entertain her application, the complainant had no other option but to approach the Calcutta High Court. Finally, the High Court granted her relief by asking the magistrate to consider her application for registration of an FIR once again. This order came to be challenged by the accused before the apex court in a special leave petition. In the meantime, the magistrate in Kolkata accepted the complainant's application and directed the police to treat it as an FIR and initiate an investigation into the allegations of sexual assault and criminal intimidation. Now, almost 17 months since the verdict was reserved in December 2021, the Supreme Court has set aside the magistrate's order directing the police investigation and once again asked the magistrate to consider the issue of whether an FIR is needed to be registered in this case. A bench headed by Justice M.R. Shah said that the magistrate had misread the High Court's order and passed orders under Section 156(3) of the CRPC without applying their judicious mind. Last week, we spoke about the wrestlers protesting in the national capital over allegations of sexual abuse and harassment against the head of Wrestling Federation of India, Brij Bhushan Sharan Singh. The sportspersons are unhappy about Delhi Police's refusal to file an FIR as well as the government's inaction. In a relief to the survivors, the Delhi Police agreed to file an FIR after the wrestlers knocked at the top court's door. This week, a bench headed by Chief Justice D.Y. Chandrachud closed the petition filed by the 3 women wrestlers whose identities have been protected, in light of the fact that the FIRs have already been registered against Brij Bhushan. The bench also granted liberty to the petitioners to approach the jurisdictional magistrate or invoke the remedy under Section 482 of the CRPC before the Delhi High Court in case of any further grievances. In a significant development in the marriage equality case, Solicitor General Tushar Mehta informed the Supreme Court that the central government was willing to constitute a committee to examine whether certain legal rights can be granted to queer couples without legally recognizing their relationship as a marriage. This comes after the Constitution Bench headed by Chief Justice D.Y. Chandrachud asked the Solicitor General whether the government would be willing to grant certain rights and protections to queer couples just as they do in the case of heterosexual couples in live-in relationships, even without the marriage tag. Thank you for watching. If you found this video useful, don't forget to like, share and subscribe. Drop a comment below on what you thought of this week's developments and tell us your suggestions on how we can improve our content. Hit the bell icon to get notifications whenever we upload a video and visit our website www.livelaw.in to read our detailed reports. I'll see you again next time.